can you help me? I've received a topic in class today for preparing project on GAAR which has to be presented tomorrow before the panelist faculty members. What is GAAR? Is there any specific provision about GAAR in Income Tax Act? Is it so useful from the perspective of the taxpayers? What resources should I look into for researching on this given topic?
Not to worry, chap. You'll be glad to know that TIOL Tube has uploaded an educational video program on GAAR which will help you to understand the basics of GAAR in a very simple and lucid way, without taking a painstaking effort researching in course textbooks and print library. I believe with that, you'll also realize the tedious job of the Income Tax Department in demarcating the honest taxpayers from that of the evaders.
General Anti Avoidance Rules, or GAAR, as the name suggests, is anti to any method used to avoid or prevent the applicability of tax on transactions specifically used to put cloak on the net income chargeable to income tax. Globally, tax avoidance has been recognized as an area of concern, and many countries have expressed their concern over tax evasion and avoidance. This is also evident from the fact that either nations are drafting a new provision of general anti-avoidance regulations in their tax code or empowering their existing code for future contingencies. With the increasing trends of integration of economy and repetitive growth in cross-border transactions, legislature of some countries have empowered their revenue departments to disallow tax benefit if the assessee fails to establish the commercial legitimacy of transaction in question. In context of India, the much hyped Direct Tax Code 2010 promised to address the need for removing the fences by legislating GAAR in addition to already existing ASAR, and when it has been proved by the Apex Court in its recent ruling of Vodafone case that India has a judicial anti-avoidance history. It empowers officials to deny the tax benefits on transactions or arrangements which do not have any commercial substance or consideration other than achieving tax benefit. It contains a provision allowing the government to retroactively tax overseas deals involving local assets. GAAR could also give powers to the tax department to deny double taxation treaty benefits to foreign funds based out of tax havens like Mauritius. The expression tax avoidance is used to describe every attempt by legal means to prevent or reduce tax liability which would be otherwise incurred by taking advantage of some provision or lack of provision in law. Tax planning may be legitimate provided it is within the framework of law. Colorable devices cannot be part of tax planning. Thus, tax avoidance could be said to transact between substance over form of a transaction. OECD leaves it to the individual countries to introduce anti-abuse legislation which they consider could be applied without interference by the Model Convention or the bilateral tax treaty between the countries inter se. However, the OECD commentary on Article 1 of the Model Tax Convention clarifies that the General Anti-Abuse Rule would override the provisions of the tax treaty. The Supreme Court in Azadi Bachao Andolan's case observed that the contention that DTAA between India and Mauritius is ultra vires is not acceptable even if the DTAA is susceptible to treaty shopping on behalf of the residents of third countries. Now, the revenue authorities have over the years challenged various forms of transactions entered into by taxpayers, specifically with regard to cross-border transactions. The recent example being the very famous case of Vodafone. In the absence of statutory provisions to the contrary, instruments and legal structures which are utilized for a bona fide business purpose do not permit an inquiry by the authorities into the underlying economic interest. However, the parties cannot conceal the nature of their legal relationship by adopting a structure which is different from the legal character assumed by them. The power to invoke GAAR is bestowed only upon the Commissioner of Income Tax. For this purpose, the Code empowers him to call for such information as may be necessary. He will determine the tax consequences of such impermissible avoidance agreement and issue necessary directions to the assessing officer for making appropriate adjustments. Under the proposed law in India, even where the main purpose of a step in the transaction or the part of a transaction is to obtain a tax benefit, the arrangement would be presumed to be carried out with the main purpose of obtaining a tax benefit. Though the provisions indicate the establishment of main purpose, it is unclear as to the methodology of determining the main purpose. Further, the absence of simultaneous business purpose or a bona fide purpose test and the mere presence of a tax benefit give rise to the presumption that the avoidance arrangement was designed and entered into solely or mainly to obtain a tax benefit. Under GAAR, the Indian tax authorities will be empowered to declare any arrangement as impermissible avoidance agreement. An arrangement has been defined as any step-in or a part or whole of any transaction, operation, scheme, agreement or understanding, whether enforceable or not, and includes any of the foregoing involving the alienation of property. If the motive behind individual steps is obtaining a tax benefit, but the overall scheme is not so, the individual steps will nevertheless be treated as an arrangement and the GAAR may be invoked. Even if a transaction is not formal or intended to be enforceable by a legal proceeding, then also GAAR can be applied on such transaction. It is provided that the consequences of such an arrangement may be determined inter alia by disregarding, combining or recharacterizing any step-in or a part or whole of the impermissible avoidance arrangement by treating the impermissible avoidance arrangement as if it had not been carried out or in any other manner that the Commissioner deems fit. However, no harm is caused where an impermissible arrangement does not result in loss to the exchequer. Accordingly, it is suggested that the words whose main purpose is to obtain in subclause 15 of clause 124 be replaced by the words resulting in. Hope this information was useful for you. In the next episode of Learning Curve, we will focus on GST and the complications associated with them. Thank you for watching TIOL Tube. You may send us your feedback or suggestions to make it more useful for you at editor@tiol.in.